Talk about witnesses. John Bolton, I'm wondering what you all think of the way John Bolton has handled this, handled his testimony.
We reached out to John Bolton, who was counsel, after the senators voted down his testimony to see whether he would be willing to submit an affidavit under oath that would still be valuable during the trial.
Even if he wasn't coming to testify?
Even if he wasn't going to come to testify.
A sworn affidavit.
A sworn affidavit, and he refused. Now, he will have to explain at some point why he is willing to put this in a book, but not in an affidavit under oath.
He's making paid speeches as well, in which he drops sort of comments as well.
Yes. You know, it is fairly inexplicable. But, you know, frankly, it's more inexplicable that when he was willing to come forward before the Senate, that the senators did not want to hear what he had to say. And for those senators, and there have been a few, to say, we didn't need to hear from John Bolton because basically the House proved the president guilty, even without him, and we should let the voters decide. They could not explain why they don't want the voters to know the full facts.
Did Bolton's attorneys explain to you why he would not even submit an affidavit?
Not that I'm aware of, no. Nor why he would distinguish between testimony in the House versus the Senate.
Was it a mistake not to subpoena him? He had indicated he would not respond to us.
Here's the thing, Anderson, and the answer is no. If we subpoenaed John Bolton, we would be in the same place with him 9 months from now that we are with Don McGahn today, which is we still wouldn't have a final court judgment. And the other thing I'll say is, had we done what the president would have you believe, and it's a hard argument for them to make that the House should have gone to court when they were in the court saying the House is not allowed to come to court. But nonetheless, had we taken the year or 2 years to go to court to try to force this testimony, the senators, the Republican senators, made it all too clear it wouldn't matter to them. They already believed the president guilty. We had proved already with the evidence we have today. If we proved it a year and a half from now with different evidence, there's no indication that would have made any difference. But we would have had the risk of going forward with this election without the country knowing of the president's misconduct, without some effort being made to protect the integrity of our elections. So I feel very comfortable with the decision we've made and the fact that we were able to prove the case even without these additional witnesses, because the testimony we already had is pretty overwhelming.
So when John Bolton's book comes out and it has whatever details it has in it, I mean, do you still want him to testify? Do you still, Chairman Adler, Chairman Schiff, do you want to call him in to testify? Do you want to?
We haven't made any decisions about that. What we wanted to do was get through the trial, which just ended, and then make a decision about next steps. And we'll have to weigh the need to validate and vindicate Congress's oversight power on the one hand, with the continuing imperative that has always been our first priority, and that is doing the business of the American people and our policy agenda, making sure people have access to health care and good jobs. And so we're going to have to make that balance.
It was interesting to me, Mitt Romney asked a question of the attorneys during the trial, essentially, which was, do you remember, what was the day that the president decided to withhold aid, and how was that transmitted? The president's attorneys could not answer that question. And that, to me, it's extraordinary to think, just on a historical basis, we have no idea, really, of the day-to-day timeline. I mean, you all did as best a job as you could of piecing together, and you were able to find out a lot of information. Mm-hmm. But the president's own attorney cannot say, oh, yeah, it was on June 3rd that he decided.
They would not say. Right. It's not necessarily that they could not say, they would not say. We have to presume that the records we subpoenaed, which would show exactly that, they had possession of.
Sure.
They don't want the Congress to see them. They don't want the country to see them. It doesn't mean that they haven't reviewed them.
So will those documents ever come out?
This is part of a larger problem, which is actually Article 2 of the impeachment. Not only did they try to hide every piece of evidence that might bear on the president's misconduct, the president sent out a general order that nobody from the executive branch should testify to Congress. Nobody should answer any subpoena. Nobody should give any information. They called it absolute immunity, which is nonsense. Now that means, besides the fact that you're trying to cover up evidence of your own misconduct, it means that you're trying to make sure that Congress has no information about what the administration is doing. Congress cannot function without information. It is our job as a co-equal branch of government to oversee what any administration is doing, to find out what they're doing in child care or what they're doing in health policy or whatever, and to react to it and to propose legislation to deal with it. A refusal to allow Congress information is basically a declaration that we're going to rule without Congress, and we're going to have an executive dictatorship.
But stonewalling
That's
works
what they would,
in this case, no?
Stonewalling has worked, and that is why we had the second article of impeachment, to impeach him for abuse of power by trying to eliminate, in effect, any congressional role by refusing all information to Congress.
It won't work forever, though. Yes. I think a couple of things are clear. And I took from Senator Romney's question, number one, that he was truly interested in getting to the facts. He asked legitimate questions about issues that he wanted to learn more about. He wasn't trying to make political statements, and I honor the way in which he did that. The second thing is the truth will come out, whether it comes out in Ambassador Bolton's books, emails down the road, a testimony by other people that were involved in this, or some future administration releases the records. People will know. The Senate decided they didn't want to know the truth when it mattered the most during this trial, but it will eventually come out.
Is there a discussion of trying to go after the documents, subpoena the documents, and have it go through the courts? And I mean, it's not something that's in the public view. It doesn't take away from the candidates running for president on the campaign trail. They're not going to be asked about that all the time.
It seems to me that there's an ongoing discussion, as Adam said, of making sure that we in the House majority continue to do the business of the American people, focus on lowering health care costs, enacting a real infrastructure plan, fixing our crumbling bridges, roads, tunnels, airports, mass transportation system, making life better for everyday Americans, as we've been doing from day one. We've passed over 400 bills, 275 of them are bipartisan in nature. Maybe the Senate will start doing something about the legislation that is sitting over there in a graveyard. At the same time, we have this oversight responsibility as a separate and co-equal branch of government to continue to just follow the facts, apply the law, be guided by the Constitution, present the truth to the American people. This is all unfolding in the context of a White House that has executed, as it relates to the Ukrainian shakedown scheme, a cold-blooded cover-up that was largely exposed, but there still is information that they're withholding. And we'll see what happens in that context. But as has been said repeatedly by the managers, the truth will all eventually come out.